I think the access to justice crisis is just so pressing, and our current strategies are just not enough to really get the numbers moving in a direction that shows substantial improvement in access.
Today on Law Next, I'm live at the Legal Services Corporation's Innovations in Technology Conference, where my guest is going to be Margaret Hagan, Director of the Legal Design Lab at Stanford Law School's Center on the Legal Profession. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment. But first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview. Margaret Hagan, welcome to Law Next.
Hi, thanks for having me.
It's a real pleasure to talk to you. And again, just to be clear to our listeners, as I just said, we are live here at this conference, so there's lots of people mingling around behind us, and you're going to hear a lot of background noise. But that's what happens at conferences, so at the price of the territory. I was thinking actually about the fact that I first spoke to you, I believe, way back in 2013 when I was writing a story for the ABA Journal on visual law. And at that point, you told me a story about how you sort of started getting into this that I'm not even sure is the full story, but I remember writing about it. Maybe I didn't get it right. But how did you get interested in this whole area of...
It was very happenstance. I didn't come to the law school thinking about innovation. I definitely came at a time where there was a lot of optimism about tech and design, especially on Stanford campus where I was studying. So I did know I wanted to get off the law school campus a little bit and go explore what other kinds of classes in the business school, design school, computer science. But really in my third year of law school, I realized I wanted to take a jump and not go on the traditional path to a more corporate legal career. I had always been a person who loves to draw and map things out, and my whole 1L law school year was spent making mind maps and cartoons of all those cases that I had to spend all my time reading. But it was only later on that I realized there might be a career path and this new kind of field of actually practicing creative innovation in law.
Yeah, I mean, do you think there are certain people who are just sort of visual? Are you a visual learner? Would you describe yourself as a visual learner? Or?
I definitely love it when there's slides and other things that help me see things schematically.
Yeah.
I mean, I have my PhD. I've done lots of reading. I can read and intake things like law school wants you to, reading large swaths of text, paragraphs after paragraph. But to really understand things, compare things, and think logically, I'm a big believer in visuals for that.
So, I mean, even as you began to, I mean, it was pretty much while you were still in law school that you began to see this as a career path, right? Because you started getting involved in this even as you were still in law school, and you went right from law school to the design school as a fellow, as I recall.
Yeah, I had a very lucky year to just figure things out and figure where there might be a career. So that was where I started prototyping this idea of a design lab in the law school. Yeah. And then after that year, I was hired to really run that inside the law school.
Yeah. And was your thinking, was the interest... We're here at a conference where the focus is on access to justice. I know you've been involved in a lot of initiatives in the years since around access to justice. But was that your thinking from the start that this was a tool, this was a way towards enhancing access to justice?
That was definitely part of it. I had taken the wonderful Professor Deborah Rohde's class on ethics in my 3L year. And she brought in all of these practicing lawyers talking about the access to justice crisis and this great underserved middle class of consumers in U.S. and how they were not being served, as well as the legal aid crisis of being underfunded and not being able to serve to capacity. At the same time as I was studying that about the access to justice crisis, I was in these entrepreneurial classes with wonderful other folks at Stanford who ended up founding very successful startups, thinking about new kinds of business models and learning about new kinds of legal tech ventures, more from the commercial or legal functions and corporation side. So that kind of crossover, I was always interested in access to justice and public interest as a main use case, But I was also hanging out a lot with folks who are trying to start up innovation efforts in more commercial and corporate settings too.
Yeah. And at what point did you actually launch the Legal Design Lab?
So the first version we started in the fall of 2013 with Ron Dolan, who's a wonderful engineer, formerly of Google, then went to law school, and then at that time was affiliated with Stanford. So he and I started off this program for legal tech and design where we were running workshops. We did some really interesting classes, working with everyone from the Judicial Council of California on access to justice things to Fidelity as they were prototyping new legal services that they might offer. And so we tried that for a year, and then the law school hired me, and then it became the design lab, the Legal Design Lab. Yeah.
It's funny because now when people talk about design thinking in law, it's almost becomes synonymous with Margaret Hagan. I mean, it's funny that you don't ever hear a conversation about it unless without your name being
That's not
somewhere.
necessarily a good thing. Yeah.
Well, I mean, it is. It's a good thing for because it's a good thing in terms of respecting the work that you've done. But I wonder what was there a history to design thinking in law before you put it on the map?
I tried. In my 2L summer, I spent a whole month trying to figure out who I could work for who was working on design thinking in law. There were one or two articles from Canada, from UK and Australia about corporate innovators, so people inside a law firm who had found design thinking and were trying it out. But there was no school class pathway. But around the same time as I started my design lab at Stanford, across the country at Northeastern in Boston, Dan Jackson and his colleagues were starting a design lab there at that law school. So there was some serendipity. There definitely was a moment in that 2013-14 era where design thinking, which had gotten really popular in the mid-2000s in consumer products and then healthcare and finances, then it started making sense to bring it into legal services.
Right. So let legal services be last to innovate.
Well, government services came after that, so don't worry. And insurance,
I guess. And yet it is, I mean, I want to say it's ubiquitous, and maybe that's only because I tend to go to all the conferences and stuff where it's being talked about, and I don't know how much it's sort of trickled down to the rank and file of law practice, and it's probably nowhere near as ubiquitous as it should be. But why do you think design thinking matters within the legal system? Why is it important at all?
I think there's a few strands. One is just the kind of problem solving and creativity that lawyers are increasingly called on to do, whether it's in their business and service models as there's more pressure on law firms or legal functions about being more efficient, providing better services. I think design thinking as a process about how to imagine new models, new ways of serving your clients better, that has a proven history of being effective. So it's a really structured, if not perfect, recipe to how to get more creative and more strategic about those kinds of venturing into new services or new business models. The other area, and I see a lot of interest in this from certain law firms and legal functions, is just in expressing and communicating more effectively, whether it's with clients, with juries, with judges. Design as a way to be more visual, to be more in tune with your audience, to make more compelling arguments and stories. So just in that very, those common work products that lawyers have to create, the slide decks, the stories, the trial narratives, the visuals, you can make better versions of those using design.
Yeah. What about in terms of access to justice? How does design play into enhancing access to justice?
So among those who are developing tech for people searching online for legal help, low income or otherwise, I think human-centered design is all about user testing and really checking assumptions that when you're a bunch of wonderful, smart subject matter experts, that you are actually writing in ways that people understand, presenting all this complicated guidance that's free and great, but can people actually use it to solve their problems? So I think that's now become pretty standard in our access to justice technology community, that we need to be doing more testing, involving more of our end users in the process, and not just assuming that we know how to get help to people. And I think there's also a growing movement to think about new business models or service models. I mean, I think the access to justice community might be a little slower than the for-profit sector in this, but I think there's increasing numbers of nonprofits that are experimenting with unbundling or other ways to get services to a wider section of Americans. So I think there is that kind of design thinking for new business models trend happening.
Yeah. I mean, I think this podcast has a pretty sophisticated listenership, I think. I mean, but do you have like a pocket definition of design thinking? What are we talking about when we're talking about design thinking?
All right, so I'll be really reductive and simplistic. And there's lots of articles, so just search design thinking. There's so much content out there. But really, design thinking at its heart is a process that you individually or a team can use when you're facing a challenge. How do we get more users to our website? How do we figure out where our relationship with our client might be breaking down and how to improve it? How to be more efficient when we're dealing with huge stacks of contracts? So the basics of a design thinking process is to spend a first phase of discovery, of figuring out and talking to a lot of stakeholders and gathering data. Where are the dysfunctions? What is going wrong? What is our status quo? And hearing as much as possible from people who are not you, so you're not assuming what the problem is, but you're going out and talking to people on the front lines of that problem who are managing the contracts or trying to use your website or who are your clients, and letting them give you a lot of input about what the agenda should be, what the problems are. Then moving to the second phase, it's about imagining a better future. So this is probably, if you think of design thinking, you might have seen pictures of lots of Post-its covering the wall or crazy brainstorms. We use all these techniques in design thinking to unlock new ideas that are ambitious, that are breakthrough, that are borrowing from other systems, from analogies, but trying to not just think of obvious ideas about how to improve whatever that problem is we're trying to fix. So using those creative techniques to come up with a bunch of ideas and then gradually test them and vet them back with our end users, with our stakeholders, and then honing in on something. And then that's kind of where the design thinking process ends and a development cycle or some other kind of production cycle begins, where you've vetted this idea. Now you can commit resources and actually build it out to pilot.
Yeah. Hey, sounds great when you're out there in Stanford, but how does that play in the courts and justice systems in Middle America, Utah accepted, which we'll talk about in a bit.
Yeah.
I mean, what are the challenges really to kind of bringing that way of thinking to the legal system?
It really depends. So in some cases, I've run a lot of one-day design workshops or 6-month processes, if not several-year processes with different court partners and legal aid partners. One of the big barriers at the start is hierarchy and kind of status quo inertia. So especially when you go into a court, different states are different from each other, but some states, a judge doesn't usually sit down with the clerk staff or with former litigants and open themselves to criticism and ask, what could be better about our court services? Or what could be better about how judges treat litigants in eviction hearing? That kind of openness and direct face-to-face reckoning with problems that might be in your system or with
it
services
requires
you
them
provide.
to admit in the first place that there needs to be, or not needs to be, but that maybe the way things are running aren't running perfectly.
Exactly. And so like that, and being willing to engage with people who are at a much lower place in the hierarchy, to also have an equal stake in setting the agenda and saying where resources should be committed or what should be considered the problem we're focusing on. Yeah. In other cases, that hasn't been a problem at all. And there's been a lot of receptivity and a willingness to say, yes, things could be better in our court or our legal aid group.
But that's you've probably seen that evolve just in the years you've been involved in this.
I think
what
there's
was
been
it?
a
Was it
huge
8 years, 7 years since you got out of law school?
Government services and this commitment to making things better and openness to possible technology solutions. other things like that. I still think that one of the big other problems at the beginning of the process is getting people away from day-to-day problems and focusing on longer-term strategic ones, especially in the legal aid or under-resourced groups where it's like we don't have resources, we can't pause what we're doing and commit to longer-term initiatives.
Yeah, I was just talking to somebody about that from a sort of a budget point of view at a lot of legal aid organizations where they're so focused on spending their dollars on dealing with the day-to-day deluge, that they don't want to invest in technology or the time to think about technology because they just need to deal with the pain as it stands now, and they don't understand that maybe by becoming more efficient or having a better design process that in the future they can actually spend less money maybe and get the same results or get better results with the same money. So what does the Legal Design Lab do? And what's your day job?
So part of it's teaching. A lot of what we do is we start off partnerships with classes. So we have a large educational component where it's almost like a clinic at a law school, but with a focus on not providing traditional legal services, but where I train the students I always teach in a member teaching team. So right now I'm teaching with a technologist, with a former eviction defense lawyer, and with a person who specializes in legal regulation. So we're a 4-person teaching team. We're very lucky. And we have 10 students, and we are partnered with our local court system in Santa Clara County and local legal aids. And we are mapping out how people experience getting evicted in the Bay Area and how the service providers try to provide services. We spent the first 10 weeks of our class spotting the major opportunities. Where could we feasibly intervene to make the system more fair and more efficient from the service provider's point of view? So trying to accommodate all these different stakeholders and from the landlord's point of view.
Yeah. Are these all law students?
No, actually we have about 4 of our 10 as law students. The rest are coming from computer science, education, these hybrid majors around social impact.
So is that by design that you want to bring together different disciplines?
So we always cross-list our classes. They always have a law school code, but they could be also cross-listed in sociology, mechanical engineering, computer science, so that it's much easier institutionally for other students to take the class and get credit that matters to them.
We'll get back to my interview in just a moment. But first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview. Why should law students, I realize there's other than law students in your classes, but why is it important for them to learn these kinds of skills?
Well, I think it's actually great practical training if they're going to be a lawyer to clients, to actually talk to clients about their experiences, how they see and experience court, lawyers, and technology resources. We also spend a lot of time in court actually just observing how the courtroom is run. We talk a lot to both the plaintiff and defense attorneys to hear why they're doing what they're doing, the strategies, the work. And also we get into a lot of policy discussions too increasingly, where we talk about why is the system set up this way and how would we change the timelines of different court processes, the forms you have to fill out, who gets to file what.
Yeah.
So it helps the law students see what they're learning in class from a more lawyerly or judge-like perspective to kind of take a step back and both question why is the system set up this way and how do people, especially litigants, actually experience it, hopefully make them a better professional.
Yeah, so is that what you want them to take away from these classes, is sort of a better perception about their own future work and how they fit into the community, the system, whatever you want to define it as. But
I know most of my students do go on to at least initially clerkships and then corporate law jobs. So clearly, just like many of my professors encouraged me, is to have an active pro bono commitment and to really pay attention to the access to justice crisis as something that really matters in this country. So of course, I would love to see that public interest commitment. But the other thing I think the students really learn is this ability to work on teams, to be deferential to other types of professionals and not assume that just because we are in a legal system problem that a lawyer knows all the answers by themselves, and how to work with technologists, how to communicate, how to plan out projects, how to kind of manage those relationships with other professionals in a much healthier and less egotistical way.
Yeah. And when you're not teaching, what are you doing?
Oh, so I do a lot of research. So I have many of my students who excel in my classes, I then hire as research assistants. So we do a mixture of kind of development technical projects where we're building an application, either more for a service goal, like with the legal aid group, to see can we increase the number of people who are accessing a service or improve how the service is delivered, or text messaging lines. And those are kind of like trying to make more access to justice interventions that work. Increasingly, we're also doing research in my team on the state of the internet around legal help. So trying to measure the algorithms of Google search or other search engines and seeing, are they showing people correct results, public interest results, and then use that as a way to hopefully make better policy about how these internet search platforms are interacting with access to justice issues.
Yeah, and is it in that research component of your activity, is that where the Learn Hands project fell into?
I think so. One of my big questions is just how we make the internet better serve people, especially low-income people in U.S., when they come for legal help. So the Learn Hands project grew out of just my initial interest in, like, why is it so hard to get people to good quality information when they're willing to go online and tell a whole story on Reddit or go to Google and write a line or two about what's going on in their lives? Why aren't these platforms showing them good information? So the Learn Hands project kind of grew out of a session at this conference a few years ago where David Colarusso at Suffolk's Lit Lab had the idea for a machine learning idea to build a classifier that would spot people's legal issues. And then I was thinking of the use case of people telling their stories online and then not getting really anything that would help them solve it. So we've been working on it for several years, and I think we're making a lot of good progress.
Yeah, and I just found out as you sat down, you spoke about this morning. So where is the stat? Where is this now? Where are you at with that?
So we have a game that's live. It's called Learned Hands. You can find it at learnedhands.law.stanford.edu, or just search Learned Hands with an S at the end. And that is a game.
Or read about it at lawsciencblog.com.
Yes. So you can play a game where you read people's stories, real people's stories, their legal problems that were originally posted on Reddit, on the subreddit Legal Advice. And you can say what legal issue you think is present in this story. Is there a family law issue present here? Is there a disability benefits issue here? Is there a Veterans Affairs issue here? All of those labels that people have been giving over the past year or so are then going into a labeled data set which lets us build machine learning models. So David and Lit Lab have been taking the lead in building those models, which are progressively getting better at predicting what legal issues, at least at a very high level, are present in these stories. So every month we're seeing those models improve. We're seeing, a healthy number of people playing that game.
Yeah.
So at least for people who write in that Reddit kind of way, we're getting better at spotting what issues are present.
Yeah, and then you're using that to refine a taxonomy of common language about the law, right?
Yeah. So it might sound boring, but it is really important to have a standard common list of all of these legal issues that people have.
Yeah.
So we've been gradually refining that with support from Pew Charitable Trusts, this giant list of legal issues. We've inherited a lot of other people's lists. We're trying to make sense of that and make sure it corresponds to what people actually are experiencing.
Yeah. So how will that, give me a use case for how that ends up getting used in the real world.
So if we have a code for paternity issues, am I really the father of this baby, or I want to prove that this man is the father of my baby, and I've written this 2-page post about it on Reddit. Something like the classifier Spot could see that this seems to be a paternity rights issue, and it could say, this seems like a paternity rights issue. That is code FA010101. That code is the important thing, because hopefully legal aid websites law help portals or chatbots have also used that same code, FA010101. And all of their great content or experts who know about paternity rights issues can then be matched to that person. So we could have a little bot on Reddit that says, it seems that you're writing about paternity rights issues and you're coming from California. Here is the court's resources about paternity issues in California. And we could direct them right to authoritative information that's applicable to them.
Yeah. So I did want to ask you about Utah because I'm really intrigued by what's going on there, and I know you've been involved in a major way in helping them think through how to approach, their concerns about access to justice in that state and how to develop the trials that they're developing now to kind of address it. But I'm gonna actually guess that a lot of our listeners probably know about it, but maybe you can just kind of sum up what's going on in Utah and how you've been involved in that.
Sure. So there's been, starting since the beginning of 2019, there was an initial task force working group of people who are thinking about what regulatory reform might look like in the Utah context. So we, at the invitation of the current state Supreme Court Justice Dino Himonas, and past bar leaders.
Who's been on this podcast, by the way.
Yes. Just a terrific group of people in Utah who are open to new ideas about what regulatory reform could look like very practically in a state like Utah. So we did brainstorming sessions, we did stakeholder input sessions, we went to innovation conferences and got ideas from entrepreneurs about what might be possible. And one of the ideas that I had been learning about at all these design thinking in the government conferences that I've been going to was about the idea of sandboxes and a way to kind of bring this notion of experimentation and agile governance, not to be too jargony, about how we make policy that's informed by data and by real empirical evidence rather than hypotheses. And this idea of sandboxes came from fintech, financial technology innovation, where governments like in Singapore, UK, Australia, others had set up these sandboxes to gather data about if we let a new technology into the market or a new service into the market, like a robo-advisor, does it harm people? Does it benefit them? Do consumers complain? What can we see from the data about if we let these new things into the marketplace, how we should regulate them and if we should relax the current rules to accommodate them.
Yeah.
So this was intriguing to the community in Utah, if we could adapt this thing from financial technology and innovation into the world of legal services.
Yeah.
So there was a report that was issued in August that confirmed that the court in Utah would support the idea of a regulatory sandbox being set up, as well as broad rules reform. So now there's a task force, an implementation task force that I'm a part of, and there's a public-facing website to start really making concrete plans about how to open that sandbox and to try this new type of regulatory approach.
Yeah. Is there a design thinking aspect to the sandbox, or does the design play into the process that led to the conception of the sandbox?
I think several of the principles are definitely there, which is having kind of multiple stakeholders involved, including our target users. So whether that's current members of the bar or other kinds of service providers that might come into the market, whether it's from legal technology companies, other kinds of service providers, other kinds of law adjacent fields, to really talk to them and say what could get you to come into the market and also to play by the rules that this new sandbox would set up. Like, we want to make sure that this actually works for our potential sandbox entrants, as well as to the end users, to the folks who would benefit from it.
Yeah.
So we're trying to make it as user-centered as possible, and also to take this iterative approach of trying things, learning, and that's the whole idea of the sandbox, is instead of changing all the regulation whole cloth or keeping it the same, that we have a controlled experiment, gather data, see what works or what doesn't, and then maybe the sandbox will fold, maybe it will continue on, maybe it'll be changed.
Yeah. It's so exciting to be able to see a state like Utah, see, judicial leaders really taking a leading role in saying, look, we just are not fulfilling our responsibility as a justice system, and we need to do something about it. And we're not sure what to do, but we're going to experiment and figure it out and try it out.
I think the access to justice crisis is just so pressing, and our current strategies are just not enough to really get the numbers moving in a direction that shows substantial improvement in access. So.
Yeah, I mean, and it's, you come to this conference, a lot of conferences you go to where people understand that, but when you get out, again, for me, I mean, I'm still practice law, and I go out and talk to lawyers, to sort of day-to-day lawyers, and they're not thinking about it, they're not aware of it, they don't see the shortcomings of the system. So I think it takes a lot of courage for the leaders of the legal leaders like Justice Simonis and others, to some of the bar leaders in Utah as well, to really take this initiative on. So I know you have to get soon to a meeting. Anything else interesting that you're working on right now?
I think the other big effort that we're focused on is eviction, knowing that there's a lot of cross government interest in improving the eviction system.
Yeah.
With Matt Desmond's book and just a lot of coverage of the news about the housing crisis and how eviction impacts poverty, there's a huge opening now for this slice of access to justice issues to really take the center stage in terms of all kinds of new funding opportunities, new policy opportunities. So our goal at the Design Lab is how to get strategic cross-country collaboration so that we can have pilots that prove what works or what doesn't, and have cities talking to each other, and local coalitions working across states. So we're really excited about trying to think at a national level of really learning from evidence about where we should be investing to make the legal system better.
Yeah. It's funny you mention evidence, because that's actually one of the problems with the legal system up until this date has been the lack of evidence-based thinking at all about any of this stuff. So how do we begin to get past that problem and begin to have more evidence-based thinking?
Well, it's terrific to see labs like the A2J lab at Harvard, which is all about randomized control trials and strong bases of evidence about, does a new policy or a new type of legal service actually get people to better outcomes. So I think the A2J lab has now inspired all kinds of other labs, even my own, to be more rigorous about the evidence we gather, and also to convince our partners, whether it's mayor's offices or legal aids or courts, that when they're trying something new, to build on this evidence gathering plan. So the goal is that if we have a national cohort, we can try 6 or 7 different experiments and then see what effect it actually has on people's outcomes.
Yeah, I mean, again, that's another one of the outstanding qualities of what Utah is planning to do, is that there will be lots of data gathered and lots of look at what's really working and what's not working.
That's one of the most exciting things, I think, is that investment that Utah is making into figuring out how to measure quality in legal services or harm. I think that's going to be really pioneering. And so whenever we talk about, we never measure lawyers, so why start now? I think it's starting now. So
yeah. Well, Margaret Hagan, I really appreciate you taking the time out of this very busy conference where you're speaking every hour or something. It seems like to sit and talk to me. It's been a real pleasure.
Thank you so much. It's great.
Big thanks to Margaret Hagan for taking the time. She's been very busy here at this conference, giving a number of talks. So I really appreciate her sitting down and talking to me today. And of course, a big thanks to the sponsor that made this show possible today, MyCase. With thousands of customers, is a trusted practice management solution, helping lawyers across the country run organized, efficient, and successful law firms. You can try MyCase for free today at mycase.com. And last but not least, thanks to Ben Ambrogi for producing and editing the show. That's it for this week. This is Bob Ambrogi.